Before we start, Lord Justice Arnold, can you hear us?
I can indeed, thank you.
Thank you.
My lady, before I come to my submissions, just one small point to pick up from a question my Lord Justice Nugee asked this morning about the return on capital. Just for his Lordship's note, there is an example of how the regulator deals with it, or has dealt with it in the past, and that's found in the supplemental bundle. That's tab 6 at page 140, where there is the outcome of the 1994 price review, and one sees at pages 193 through to 195 the consideration of return on capital, and at the end one sees, however, the director has not has set price limits on the expectation that real returns for most companies would fall over the 10 years covered by the new price limits to a range of 6 to 7% after corporation tax. Returns for water-only companies can be expected on average to be above those for water and sewage companies. So you can see it's an example.
Yes, thank you.
Lady, coming back to our submissions, we've reached the position where the unchallenged evidence on the nature of the infrastructure was, as I explained this morning, as indeed the consequences of discharges. The unchallenged evidence is that the only way to remedy the sort of complaints with which we are concerned in this litigation is the provision of further infrastructure, because we're not concerned with negligence or intentional, willful acts which cause harm, and one seeing the unchallenged evidence about the nature of the new infrastructure and how substantial it is. And we've picked up points in the skeleton argument. Against that background, we make our submissions under 3 headings. I'm first going to deal with how the Marchich principle applies to the to the 1991 legislation generally, before one looks in more detail at the provisos. I'm then going to say what is the effect of the provisos, which we've dealt with to some extent already, but I'll make 1 or 2 additional points. And then I'll look briefly, because I hope I'll have answered it by looking at Marchich, with what are the remedies if there is a breach of the provisos. After those 3 submissions, I'll deal with the points made by Mr. Hart and the interveners, including reference to the rich jurisprudence, which I'm afraid might take some time, but I'll deal with it as quickly as I possibly can. Dealing then with what we say about Marchich and the principle it stands for, as we've indicated, in essence, what we say is if a claim arises out of circumstances which involve either, firstly, a failure by a sewerage undertaker to provide sufficient sewers as required by section 94(1)(a), or a failure by the undertaker to provide sufficient infrastructure effectually to deal with the contents of those sewers, then such a claim can't be brought in court if the remedy for such a claim is in substance a requirement that the sewerage undertaker provide new or additional infrastructure. That is because we say, consistently with Marchich, such a remedy would be inconsistent with the statutory scheme. And I'll pick up my Lord Justice Nugee's point about what we say Lord Hoffman is saying in due course. Before we look at Marchich, it would be helpful, I respectfully submit, to look at 2 post-Marchich cases, including one decision of speech of Lord Hoffman, which deals with what the House of Lords Supreme Court has subsequently considered Marchich to stand for. So I propose...
Well, just before you get into the detail, could I ask a high-level question first of all, which is this. You say, and I understand the basis on which you made the submission, that to do anything about the acts complained of would require new infrastructure and all the investment that's required. What do you say to the point made by Mr. Hart that that's not what they're asking you to do? All they're asking you to do is to pay a rent.
Well, dealing with the point made by Lord Justice Nugee in answer to Mr. Hart, in essence, any rent in a commercial negotiation is going to take into account the price we would pay to avoid having to provide new infrastructure. And that cost is itself going to have to be borne either at the expense of resources which could be allocated elsewhere or passed on to the customer. And we say that balancing exercise is one, that valuation exercise expressed in those terms makes it clear that such a remedy, if the court were to consider it, would be considering, in essence, albeit 1 degree removed, the provision of additional infrastructure.
Well, I understand that submission, but the correctness of it seems to me possibly to depend on the correctness of an unspoken premise, which is that if the court exercises its power under the modern equivalent of Lord Cairns's Act to award damages in lieu of an injunction, that the damages that are awarded are open-ended. That is to say, the negotiating damages will reflect the ability of someone to charge a monopoly price, which is kind of your situation. But is that necessarily correct? Because why is the court not able to say that the damages shall be subject to a criterion of reasonableness?
Well, the problem we have in that situation is that the court, in considering reasonableness, would be entering into consideration of the very factors which we say, when one looks in particular at the Section 2 duty, are to be balanced by the regulator or the Secretary of State, respectively. So, although it's at one degree removed from the issue of infrastructure, the balancing exercise, the economic impact, the effect on consumers, the effect on the ability to provide infrastructure elsewhere, we say the court would, in essence, be being asked to undertake matters which are fairly and squarely within the remit of the regulator or Secretary of State under the Act. And that's the way we answer it. Though your Lordship is quite right. Current jurisprudence on the measure of damages in lieu of an injunction indicates that the court does have a wide-ranging discretion. But the way I answer your Lordship's point is that in exercising the discretion, the court will have to trespass upon is perhaps putting it too high, but it would have to consider the very same factors which or substantially the same factors which the regulator would have to consider in determining whether new infrastructure is provided. and indeed in setting price, not just in provision of new infrastructure, in setting prices for the next AMP period. Because, of course, the question of what rent is paid is something that feeds into that which the regulator, the sewerage undertaker rather, can pass on to the customer through charges, and in respect of which the sewerage undertaker is entitled to a return. Viewing this...
Well, before you go on, Mr. Karras, I think what this exchange reveals explains a feature of this case which has been troubling me, and I haven't been quite able to put my finger on why until now. But I think I'm now able to articulate it, which is this. It seems to me that the way both sides are approaching this case is a bit unsatisfactory. On the one hand, you argue the case as if the claim were for a mandatory injunction. I understand forensically why you do that. But it seems to me that it fails to meet the reality that it's not a claim for a mandatory injunction. On the contrary, the claimants are eschewing a claim to injunction. They're expressly saying, we don't want an injunction, we want damages in lieu. Equally, for their part, the claimants say, well, we just want a rent. But neither side has put before the court any of the jurisprudence on the applicable principles with regard to the assessment of negotiating damage.
Well, it's quite true, my lord. We haven't put before the court jurisprudence on that, directly on that. Though I'll take your lordship to the one case we do refer to in a moment, which is Supreme Court authority. The starting point, of course, for whether or not damages are awarded instead of an injunction the Lord Cairns's Act is engaged, we say, following on from the Coventry and Lawrence case, which is in the London, which we do cite and we refer to in the skeleton argument, is the court's jurisdiction.
Well, Coventry and Lawrence is about the circumstances where you're deciding whether or not to grant the injunction or whether to award damages new. It's not about quantification once the discretion has been exercised to award damages anew. So it doesn't really help on this point.
Your lordship is quite right, save for the dicta of Lord Carnworth at the end, which indicates that he is by no means certain that negotiating damages, in essence, is the correct measure of damage. So there are dicta at the end. So your lordship is quite right. I'm not running away.
There is, of course, Supreme Court authority on this question, as I'm sure you're well aware. But I'm going to shut up in a moment. But before I do, I just want to make one last point, because I think it's germane to your analysis of Marchich, which you're just about to embark on. And the question I want to just leave hanging for you to answer, not immediately, but in due course, is this. My present understanding of Marchich, which may be wrong, is that it's all driven by the nature of the claim that Mr. Marchich was making, because he didn't just want money, he wanted to stop his house being flooded with sewage repeatedly, several times a year. True it is that he did want compensation for the steps he himself had taken to try and to deal with the situation, but fundamentally, what he was asking for was remedial works. And I wonder if, therefore, the present case is possibly to be distinguished from that. Now, I'll leave that question hanging and let you make your submission.
Well, my lord, I'm obliged. It is a point that we deal with in the skeleton argument already, but it is. I can understand very well why your lordship is troubled by it, and we'll come back and perhaps expand upon it in due course. But I respectfully submit the answer to it is, as I have explained, that the very exercise of the discretion by the court in assessing what level of damage is appropriate and the correct measure of damage involves the court considering the very same matters which will feed into its discretion as the regulator has to consider, and indeed will affect the priorities which the regulator has to consider, because money which we have to pay will be recovered from consumers, and money which we have to pay through investment is something to which our investors are entitled, on the face of things, to a return. As well as
That's the subsidiary point. The initial point is, as soon as the court is considering the award of damages, it is playing with the same building.
Exactly.
Exactly. That is impermissible.
Exactly. That's the answer, and the subsidiary points were examples.
Can I pick up my lord's point on quantum of damages in lieu? Because I understood, I may have misunderstood, but you to be saying earlier, well, the rent that you would have to pay in an open negotiation would be driven by the cost to you of providing an alternative outfall. When one looks at damages in lieu, you get it in rights of light cases, you get it in root and part restrictive covenant cases. The claimant doesn't get 100% of the profit that the defendant's going to make. You get a percentage.
It won't get it's driven by, and of course the valuers will cite Stokes and Cambridge as if it were some sort of binding authority, as opposed to merely an indication of how the bargain might go in practice. So I'm not suggesting that we give up 100%, but what one is doing.
So it might be a lot cheaper for you to pay a rent assessed by the court as damages in lieu than to actually provide alternative infrastructure.
We would say it inevitably would be.
But then that picks up my latest point. It would still involve, where does that money come from? How do you balance the interests of investors? How do you balance the interests of consumers? How do you balance the priorities of other infrastructure or other calls on your money?
Your lordship has my point precisely.
Thank you.
My lord, if I can leave that there, and my lady, turn to the case law, and as I indicated before, dealing with Lord Justice Arnold's very helpful point, although slightly out of order, it is important in understanding the parameters of the case. If I can look at 5 cases, and I'm going to look at 2 cases post-Marchich to illuminate what Lord Hoffman thinks he was doing in Marchich, which may help understanding what we say the ratio of Marchich is. If, first of all, I could turn to the Deutsche Morgan Grenfell case, which is in volume 2.3 of the authorities bundle at tab 52. It's at page 652. This was a case in which tax had been overcharged, and the question was whether a restitutionary remedy was available or was inconsistent with the tax code. And the question was whether a cause of action for restitution founded on the law of mistake survived the statutory scheme, and it was held that it did. I needn't detain your ladyship with the details of the case, but I'd refer your ladyship to 3 paragraphs. Firstly, in the speech of Lord Hoffman at paragraph 19 on page 662. It's really at H, having considered the background of the case, the question is in the end one of construction. When a special or qualified statutory remedy is provided, it may well be inferred that Parliament intended to exclude any common law remedy which would or might have arisen on the same facts. And there he refers to Marchich, and he concludes there's no reason to exclude it in this case. And while we're there, Lord Hope deals with similar point on page 674 at paragraph 55. again, first sentence, what the principle that Marchich stands for, Parliament enacted a statutory scheme which is inconsistent with the common law remedy. So again, we're looking at remedy, and on page 700, paragraph 135, Lord Walker Lord Walker puts it slightly wider. When Parliament enacts a special regime providing special rights and remedies, that regime may, but not as always, supersede and displace common law rights and remedies, or more general statutory rights and remedies, and whether it is a question of construction. And he cites Marchich. So although these are small gobbets, one can see three law lords, including Lord Hoffman, expressing the principle succinctly in terms of inconsistency of remedies. And in the same bundle, my learned friend took you to Child Poverty Action Group. I can deal with it quickly. It's tab 58, page 945. I'm sorry, it's in the next bundle, 2.4, page 945. As your ladyship will recall, the case concerned the recovery of common law of overpaid social security, and it was held that the Secretary of State had no power apart from statute to recover. We don't need to look at the statute. But Lord Dyson considered the issues, and you've been taken to some passages. If I can take your ladyship first to paragraphs 26 to 27 on page 959. Which sets out the issue and refers to the question of the displacement of the common law, referring to Deutsche Grenfell. So that's asking effectively the Marchich question. And he goes on to start to answer the question, having reviewed the position, at the end of paragraph 31, just by F, before the sideline. Rather, the question is whether, as a matter of statutory interpretation, Section 3071 is an exclusive code for the recovery of overpayment. The question is to be answered not by applying any presumptions, by saying that the common law remedy in restitution is not displaced unless, as a matter of logic, it cannot coexist with the statutory regime for recovery. He then goes on to consider the matter more detail. Then over the page, at paragraph 33, he says, if the two remedies cover precisely the same ground and are inconsistent with each other, then the common law remedy will almost certainly have been excluded by necessary implication. To do otherwise would circumvent the intention of Parliament. Again, an emphasis on remedies. And a good example of this is Marchich. And he indicates it would run counter to the intention of Parliament. And the question is not whether there are any differences between common law remedies and the statutory scheme. There may well be differences. The question is whether the differences are so substantial that they demonstrate that Parliament could not have intended the common law remedy to survive the introduction of the statutory scheme. The court should not be too ready to find that a common law remedy has been displaced by statutory one, not least because it is always open to Parliament to make the position clear by stating explicitly whether the state statute is intended to be exhausted. Then we come to the sentence where, which my Lord Justice Arnold picked up, the mere fact that there are some differences, and this of course is referring to the back to the start of the paragraph. between the common law and statutory remedy is unlikely to be sufficient unless they are substantial. Of course, substantiality depends on the statutory scheme and the nature of the remedy. It's not necessarily going to be simply one of comparing the amount, the quantum under one scheme with what you might get at common law. Substantiality, we say, is a matter of statutory interpretation. And then the question is, we say this is the ratio, the question is whether looked at as a whole, a common law remedy would be incompatible with the statutory scheme and therefore could not have been intended to coexist with it. So again, we're looking at remedy. So that's the background, and we say the way the Marchich principle is to be understood and applied. So if we now turn to Marchich itself, which is in volume 2.3 at tab 51 on page 622. Your ladyship will be well familiar with the facts, so I needn't take your ladyship to the head note. But I do propose just to go through the structure of the judgments of the speeches of Lord Nichols and Lord Hoffman and explain why we say, in substance, when read properly, they are consistent, despite a couple of paragraphs in Lord Hoffman where he deals with a historic position. So, my lady, paragraphs 1 and 2 of the speech of Lord Nichols starting on page 629, set the context. He starts his consideration, having looked at the facts of the statutory scheme at paragraph 10, having looked at the history, picking up my Lord Nugee's point on the first day, going back to the
yes,
statutes.
Just so as we're clear, the understanding that I was articulating earlier emerges from paragraph 7 of Lord Nichols' speech, where he says, from B onwards, that Mr. Marchich constructed his own flood defence system in his front garden, cost £16,000. To an extent, this alleviated the damage, and there was a compensation claim in respect to that. But it goes on. But the only effective solution is enlarging or extending the existing public sewerage system. New public surface water sewers are needed to provide additional capacity to cope with heavy rainfall. So in substance, as we can see from paragraph 8, what he was asking for was a mandatory order compelling Thames Water to improve the sewerage system as well as damages for the past.
My lord, yes, I understand the point. I've given the one part of the answer already. We've set out some of the answer in the skeleton, to which I'll come when we look at the judgment of Mr. Justice Fancourt, who dealt with this point in a way similar to the point which I made in answer to your lordship. In essence, we'll come on to the remedies, which we'll come on to the way that Lord Hoffman dealt with the matter in paragraph 70, which we will respectfully submit assists in understanding how claims for damages in lieu of an injunction should similarly be approached. I'll come on to that. I'm very grateful to your lordship for indicating the genesis of your lordship's question. So paragraph 10, he starts his consideration. Paragraph 12, his lordship emphasised the financing regime and role of the director, now Ofwat, in balancing the exercise, and the balancing exercise which needs to be undertaken. Going on to paragraphs 15 and 16, having set out the provisions for enforcement, Lord Nichols, starting at 16, indicates that contravention of statutory requirement does not necessarily result in an enforcement order. And that is consistent with what we've been respectfully submitting. Enforcement is a matter for the discretion of the regulator. Then at paragraph 17, he deals with section 22. Paragraphs 18 and 19, he deals with duty. Then in paragraph 20, he deals with a freak event. No one would suppose that external sewer flooding of residential property of the character and frequency suffered by Mr. March, which in recent years is compatible with Old Church Lane, being effectually drained. So the event is, on the face of it, a breach of the section 94 duty. Then he deals, paragraph 21, with the starts with the meat of the analysis, setting out Mr. March's difficulty, and he explains that section 94.3 provides for enforcement under section 18. Hence, he says, as provided in section 18, the remedy in respect of a contravention of the sewerage undertaker's general drainage obligation lies solely in the enforcement procedures set out in section 18. And I refer to the rest of those paragraphs. But at the end of paragraph 22, it's a point I'll pick up when we come back to section 18, he says the closing words of section 18 expressly preserve remedies for any causes of action which are available in respect of an act or omission otherwise than by virtue of being a contravention of a statutory requirement enforceable under section 18. And of course, in this case, the issue here was that there was a remedy inconsistent with section 18 enforcement powers when read with section 94. Therefore, section 18.8 did not assist. Then, paragraphs 23 to 25, it deals with the evidence of costs, the cost of rectifying the situation. 24, he deals with the fact that we emphasise that consumers would have to pay. And at paragraph 25, he deals with the balancing exercise in fixing charges, including the need for investment and the need to maintain the sewerage infrastructure as a whole. And we say, in essence, that is engaged, or that exercise is engaged whether one is considering paying money or ordering the payment of money or ordering more infrastructure. Then, jumping forward, at paragraph 29 and following page 636, at paragraphs 30 to 32, he explains that the Court of Appeal distinguished authorities on the previous legislation on the basis of a distinction between misfeasance and non-feasance, and on that basis the Court of Appeal had concluded that Thames Water was subject, as any other landowner, that an occupier must do that which was reasonable in the circumstances to prevent hazards spreading. So effectively they were saying that Sedley, Denfield and O'Callaghan applied to sewerage undertakers. Then at paragraph 33, jumping forward, he deals with Goldman and Leakey, which follow on from Sedley, Denfield and O'Callaghan. And he says this: Goldman and Leakey exemplify the standards of conduct expected today of an occupier of land towards his neighbour. But Thames Water is no ordinary occupier of land. The public sewers under Old Church Lane are vested in Thames Water pursuant to the provisions of the 1991 Act as a sewerage undertaker. And Thames's obligations regarding these sewers cannot sensibly be considered without regard to the elaborate statutory scheme of which Section 179 is only one part. The common law of nuisance should not impose on Thames Water obligations inconsistent with the statutory scheme. To do so would run counter to the intention of Parliament as expressed in the Water Industry Act 1991. Then in paragraphs 34 and 35 it explains why the claim in nuisance is inconsistent, and what his lordship looks at is the substance and result of the claim rather than the form.
Yeah, and it comes back to the question I was asking before, because at paragraph 34, the way he puts it is this: Mr. Marchish's claim is expressed in various ways, but in practical terms, it always comes down to this: Thames Water ought to build more sewers.
Yes.
That's the only way Thames Water can prevent sewer flooding Mr. Marchish's property.
Yes, and we say, in essence, the only way in which the wrong, for which is at the essence of the claim which the Manchester Ship Canal makes in the court, is that we have not built more sewers. We should build more sewers, but if we don't build more sewers, we have to pay them. And and of course, what was not in play, though it is referred to in the judgments, I think, is the provision of Section 95, where, of course, there is provision within the statutory scheme for monetary compensation. So come back to that in more detail, but the statutory scheme here, under Section 95, allows the Secretary of State, having regard to his Section 2 duties, to provide for regulations which deal with the consequences of a failure effectively to deal with sewers under Section 94. That is part of the statutory scheme which is in play when one considers financial remedies. Yes. Well, and indeed, Mr. Marchridge did not only did he claim an injunction, he did claim damages as well. There wasn't a suggestion by the House of Lords that his claim for damages should survive and only his claim for an injunction should not. It was not simply a claim for an injunction, it was a claim for damages as well.
And Lord Nichols deals with that also at paragraph 35.
Yes. And it's a point. That's the point to which I was about to come. Yes. Rather than read it out, I rely on the whole of that paragraph. And picking up the point which I just made about Section 95, one sees that at paragraphs 44 to 45, Lord Nichols acknowledges the provision could be made for compensation in these circumstances, but none had been made. And that's a matter, he says, for the Director and others to consider. And indeed, the Secretary of State considered the position, and there are regulations now in place to deal with the position Mr. Marchridge and others are in.
Would it be possible for regulations to be made requiring compensation to be paid to the owners of watercourses whose watercourses were polluted?
Yes, because there'd be a breach. There would be a breach. Perhaps we should take up Section 90.
Well, no, that's all right. That's all right.
Yeah, well,
I'm just looking at what Lord Nichols says in paragraph 45. He says, in principle, if it's not practicable to carry out remedial works, those who enjoy the benefit of effective drainage should bear the cost of paying some compensation to those whose properties are lower down. I mean, why doesn't the same apply to those whose watercourses are polluted?
Yeah, well, indeed, that's the case. It comes through the statutory scheme, because the compensation provisions come. The funding of compensation is a matter that will be taken into account when provision is made for AMP periods. Of course, how it is taken into account, whether it's taken into account fully, is a matter for the Secretary of State in formulating, in accordance with his duties under Section 2, the relevant regulations. As we say in response to the interveners in this case, the complaint really should be directed with respect to the Secretary of State in failing to provide a remedy under Section 95. And that may be the consequence of the judgment of this court. Who knows? Then on to paragraph 48. Lord Steyne agrees with both judgments. So on the face of things, both judgments, both the judgment of Lord Nichols and of Lord Hoffman, on the face of it, he considers the approach they are taking to be consistent. Then,
so that's Lord Scott, of course.
Yes. So we have two majority judgments. And if I can do the same exercise in essence with Lord Hoffman's judgment, say what I say at the stages of the reasoning. At the first point to which we draw attention, we start at paragraphs 49 to 51, where Lord Hoffman noted that Mr. Marchridge was not on the face of things seeking to enforce the Section 94 duty. He couldn't because of the express terms of Section 18, he says. So we say that's an indication. It's not a form that one looks at, it's substance. Then the second part of the judgment, we say, is found in paragraphs 52 to 54. And here, Lord Hoffman, we say, is identifying the problem. In paragraph 52, we say he's posing the question whether there's a cause of action for a failure to provide new sewers. And that's picking up the point my Lord Justice Nugee made this morning. That's what he's asking there. That's the question. Then at paragraph 54, he notes that until the decision of the Court of Appeal, in this case, there was a long line of authorities that a failure to provide new sewers is not an actionable nuisance. So that's dealing with history in answer to the question, is there a cause of action? Then the third part, paragraphs 55 to 56, he sets out authorities for the proposition about the long line of authorities, and he endorses the summary of Lord Justice Denning in Pride of Derby at paragraph 55. So this is now dealing with history. He's not endorsing anything in Lord Denning's judgment other than the Gobbet which he cites. And then the fourth part of the judgment is at paragraphs 57 to 60, where he deals with the Court of Appeal's treatment of those earlier cases. I don't propose to read those to you. Then, at paragraph 59, he says the Court of Appeal is effectively saying the Court of Appeal thought cases were about misfeasance and non-feasance, and Lord Hoffman rejects that in the second sentence of paragraph 59. I find this statement, the distinction between misfeasance and non-feasance, surprising when one considers that Lord Justice Denning in the Pride of Derby went considerable lengths in the Pride of Derby to point out that there was no such distinction. And he refers to Barron and Portslade Urban District Council, which a local authority had been liable for omitting to clean a sewer. A much narrower proposition, which at page 190, Lord Justice Denning thought was supported by the four cases, was that a local authority does not continue a nuisance emanating from a sewer merely by doing nothing to enlarge and improve the system. In other words, the four cases are not about general principles of the law of nuisance. They're cases about sewers. Then he goes on to note that the cause would be considered that the Sedley, Denfield and O'Callaghan principle applied to sewers, but he notes that this was in fact rejected by Lord Justice Denning on the basis that sewers were treated differently by the cases. Then we say paragraph 61 and following is the meat of the reasoning. The earlier paragraphs of 52 and so forth are setting the scene, asking the question, is there a cause of action? But the answer to that is found in the following paragraphs, culminating, we say, in paragraph 70. So, at paragraph 61, he asks the question. This is the fundamental question that he's answering in what follows. The question is, why are sewers treated differently? At 62, he sets out the position between general landowners. Then at paragraph 63, he explains why the exercise is different where sewerage undertakers is concerned. The answer, we say, he says, is that sewers depend on questions of public interest. Then in paragraph 64, he tells us in terms, we say, that these cannot be dealt with in ordinary litigation. He tells us that this was the case in relation to the previous regime. And then at paragraph 65, this is important. He explains that the enforcement procedure in the 1991 Act is much more elaborate. He explains the role of the director, now Ofwat, and his duties to consider factors such as the return on capital, which were not part of the previous regime. Then paragraph 66 and 67, he explains how this is worked out in practice, and you've seen that brought up to date to some extent in the evidence of Mr. Hazlitt. At paragraph 68, and this we submit is an important paragraph, he explains why the Court of Appeal was in no position to take account of the statutory factors which Parliament has laid down. The director, now Ofwat, must take into account when determining whether new infrastructure should be provided. Then paragraph 69 and 70 indicate that issues of the adequacy of infrastructure are not justiciable in court. And we say the ratio of the judgment is found in paragraph 70. And we submit three things can be noted about paragraph 70. What he says in paragraph 70, what he's doing is what he refers to the most powerful argument. So this is the ratio. This is the reasoning he holds that there is no cause of action available. And the reason there is no cause of action available, he says, it's a matter of statutory construction. And as a matter of statutory construction, his reason for rejecting the survival of a common law remedy is its inconsistency with the statutory regime.
Can I just ask a small question about that? Suppose a sewage undertaker decides of its own volition that it would be a good idea to build a new sewer, and suppose that that's going to run over a private landowner's land, and suppose that the sewerage undertaker thinks that it's going to be advantageous to negotiate the right to do that by private treaty with the landowner and agrees to pay a rent to the landowner for permission to do that, rather than to use statutory powers. Is there anything to stop the sewage undertaker doing that? And if so, how does Ofwat get involved?
Well, the way it works is this. For every 5-year period, as explained in Mr. Hazlitt's evidence, if I can summarise it very crudely, the sewerage authority will make a bid for the amount of money it needs for investment, including matters it will provide by private agreement or compulsory purchase or simply the exercise of those powers. And as a matter of the open challenge, within the open challenge process, there'll be a discussion with the environment agencies to the extent to which these matters are needed for environmental purposes, and Ofwat will consider whether or not it's reasonable to set aside money to purchase the rights which your lordship has posited, and it will only be able to fund such improvements if and pass those matters on to customers if approved by the authority, by Ofwat. That's in essence what goes on. The funding for that.
I understand that general description of the scheme, but it's not a complete answer to my question. So my question has two parts. So the first part is, can the sewage undertaker do it? And I take it you accept it that he can. Then the second part of the question is, how does that fit within the regulatory's supervision? And what you describe is a process of what one might call aggregate supervision. I don't understand it to be the case unless if I've got it wrong, please tell me. But Ofwat examines each and every scheme proposed by each and every undertaker to find out how it's going to be financed and whether that's reasonable.
Can I just take instructions on the precise details of the I think granularity is the modern word. I'm overhearing what's being related to my learned junior. The way Ofwat will allocate expenditure will be that it will be on the basis that sewerage undertakers, as one might expect, would be expected to use their statutory powers and the limit and the which of course they provide for levels of statutory compensation, whether for injurious affection or through compulsory purchase. So they are limited in what they could negotiate by private treaty through the budgetary system. Of course, in theory, your lordship is right. They might have, they do have powers to invest in infrastructure outside the statutory scheme. But the problem with that is that they will not get a return on that as envisaged by the scheme. And that's really perhaps why I took the court right back to the mischief at which the legislation was originally aimed, it was a matter not simply of, as I indicated to your Lordship, privatisation for privatisation's sake. It was privatisation to secure investments which would, by its nature, have to secure a reasonable return on that investment in order to achieve various improvements, both in the environment and in service of quality to customers.
To be sure, but one can see both from the white paper and from the legislation itself that part of the philosophy is that commercial operators will be efficient. And part of the way in which they will be efficient is because they will be smart in the use of their own money. And therefore, the basic approach is one of private commercial activity subject only to regulatory supervision. The regulator's function is not to micromanage. That's right, isn't it?
My Lord, I accept that. I accept that entirely. However, both the way the AMP period works and both the money which can be set aside for investment, the charges that can be passed on to customers, and the return which can be achieved by the statutory undertakers are matters well and truly within the remit of the regulator. Now, within the resources allocated through the AMP period to the statutory undertaker, the sewerage undertaker has a discretion. However, it as your Lordship has indicated, that discretion may be a wide one, but it is hemmed around by the resources which are allocated to it in accordance with priorities set by the regulator Ofwat in conjunction with the Environment Agency. It's not a free agent to set its own priorities. The priorities for investment are effectively set in consultation with Ofwat and the Environment Agency, as is apparent both from the statutory scheme and indeed the way it's described in the evidence of Mr. Hazlitt.
So, would I be right in summarising the position in this way, that there's nothing wrong in rent seeking by owners of private property? They're entitled to exploit their property rights in the way that they see fit. However, as I understand where your submissions really end up, it comes to this, that it's one thing for the undertakers in the exercise of their own commercial discretion, subject to the regulatory supervision to which they are subject in the public interest, to decide that it's a good idea in a specific instance to pay rent to a private property owner to lay a sewer, because that's the most efficient and cost-effective way of doing it. It's another thing altogether for that to be foisted on them by the private rent owner in circumstances where they don't think, the private property owner in circumstances where they don't think that's a good idea.
Well, I'd put it slightly differently from that, but your Lordship is halfway there. It's not just that they don't think it's a good idea, that may be a factor. It's where, for instance, the Environment Agency don't think it's a good idea because they don't consider it a priority, where they consider that investment should take place elsewhere. And that, of course, may feed in to what Ofwat decide. So, yes.
But sorry, I don't understand that aspect of your answer. What's the Environment Agency got to do with it? Yes, of course, they set priorities for prosecutions, but they don't micromanage the design of the system any more than Ofwat does, do they?
Well, there are 2 points. First, as explained in the evidence of Mr. Hazlitt, which I'll come back to at the end, the Environment Agency has an important role in setting the priorities for each AMP period, the level and nature of the investment which must be undertaken and will be funded during each AMP period. There's what's called the open challenge process, and the Environment Agency is embedded within that process. The environment objective is part of essentially as part of its duties, the regulator has to consult with the Environment Agency in setting priorities. And the Environment Agency being seized of matters relating to the environment. So environmental factors feed in at a macro level, to use your Lordship's language. I'll come on to the micro level in a moment. At a macro level, during the AMP process, they also engage at a micro level on a day-to-day basis by discussing on an outfall by outfall basis the amount of pollutant which is permitted under the environmental permitting regulations. So they come in at two levels at least. Firstly, in the process of funding and setting balances for the AMP period, but also in the day-to-day management of each outfall, what is acceptable to them under the environmental permitting regulations. Before one comes to enforcement, one needs of the permits, one needs to issue the permits, and of course the nature of the permits granted by the EA at the micro level feeds in to what the sewerage undertaker will bid for the next AMP period, because if the Environment Agency on a micro level says we've got to tighten up the permits here, we require an improvement, then in making its bid for the next AMP period, the undertaker will take that into account and say, well, yes, we're going to need to provide for a new sewage outfall here, or better filtration there, and we need to build that into our bid. So the Environment Agency is very much bound up at every level of what the sewerage undertaker is engaged in. Yeah, my learned junior points out we've set this out in the evidence. If you go, your worship goes to the supplemental bundle, tab 5 at page 120. One sees the way it works in practice from paragraph 70 and following. And in particular, 75 and 76, he talks about the National Environment Programme, which is now called the Water Industry National Environment Programme. And one sees, particularly at 76, the NEP is made up of specific environmental improvements schemes, together with investigations to assess the extent of any work required in future in respect of situations where the environmental impact is unknown and evidence is required. It is developed by the EA and Natural England from the River Basin Management Plan. This is a series of documents produced by the EA under the Water Framework Directive. Then he goes on to deal with it, how the EA sets the regulatory and operational requirements within which the NEP operates. So in order to understand how it works, I flag up really paragraphs 70 right through to, and it is quite extensive, through to 85, which deals with effectively how the capital programme is set, having regard to water quality matters with input from the EA, and then he goes on to deal with economic regulation from paragraph 86 and following. So I hope that gives your Lordship a flavour, at least, of what we say the position is. And your Lordship is quite right to interrogate this, because perhaps we hadn't emphasised it sufficiently in the skeleton argument. So coming back to where we were, if I may, my lady, in paragraph 70 of the judgment of Lord Hoffman, we say, we draw attention to three things. It's the most powerful argument. It's a question of statutory construction, and his reason for rejecting the common law remedy is inconsistency with the statutory regime. So while at an early stage he poses the question, is there a common law cause of action, and looks at the history, when it comes to how he decides the case, he, having asked the question, is there a common law cause of action, he said, well, no, because the remedy provided would be inconsistent with the statutory scheme, and that, we say, is entirely consistent with the speech of Lord Nichols. I hope that at least gives my Lord Justice Nugee an inkling of how we say the structure applies, and answers the question about the tension between, or the seeming tension between the judgments of Lord Nichols and Lord Hoffman. We say it's only a tension if you read those two paragraphs to which my learned friend Mr. Hart took you to in opening.
Well, what I was reading, just so you know, is paragraph 81 of Lord Justice Hickenbottom's judgment in Southern Gas Network,
well,
where he says, I don't find the Marchich an easy case. The approaches of Lord Nichols and Lord Hoffman seem to be very different.
And that was indeed a judgment to which I was going to take your Lordship, but I don't think I need take your Lordship to it now, because in what I have said, now I've given the answer to Lord Justice Hickenbottom's...
His analysis is wrong.
Well, his confusion stems from focusing on two paragraphs which pose a question and answer it in terms of... he asks the question in terms of cause of action, but what he doesn't do, and we don't know what argument he had, what he doesn't do is focus on the reason that Lord Hoffman gives, which is at paragraph 70. So it was obiter in any event, so he didn't need to deal with it. So yes, to the extent that Lord Justice Hickenbottom found it difficult, we say, if one reads it again, it's not so difficult, and Lord Justice Hickenbottom didn't have the benefit of the argument your Lordship has just heard. If I could be so bold.
So he was wrong.
He was wrong.
Well, he may not
all he did was express doubt, so or found things difficult. And to be fair, it's unless one reads it very very carefully and structures it as I've suggested, what one can easily slip into error.
Thank you.
My Lord, we then come on, if I can leave that point, if we can then, my lady, come on to Dobson. But before we come on to Dobson, if I can just reiterate where I got to on section 18.8, or where I ought to have got to if I didn't express myself quite sufficiently clearly this morning. But picking up on the way Lord Nichols put it in the passage I referred you to in Marchich, we say, as indeed Lord Justice Nugee said this morning, the primary function of section 18.8 is to limit remedies. What it says is that the only remedies for breach of section 18 will be those stated in the statute. And then in doing that, it excludes causes of action for breach of statutory duty. And then it states there will be the remedies apart from statute will be available, and that's not controversial. The question for this court, of course, is what the remedies are. And if we can turn just briefly again.
Just before you do that, on the question of whether there's tension between Lord Hoffman and Lord Nichols, if there is there not a simple answer to it, which is paragraph 73, Lord Hope? Because unlike the other members of the court apart from Nichols and Hoffman, he agreed just with Lord Nichols. So therefore, the binding decision is that of Lord Nichols, not Lord Hoffman, if different.
Yes, well, that would be an answer if there is a tension. But as I've tried to indicate, if one looks at paragraph 70 in particular, we submit that there is no such tension. But your lordship is right to point that particular point out. But as we've seen in the later cases, of course, particularly Deutsche Grenfell, Lord Hoffman himself expressed the principle in Marchage to be the narrow one of the inconsistency of remedies. So that is an indication of what at least he, at a later stage, considered himself to be doing in this case. But I take your lordship's point entirely. But if we can now put Marchage away, but if I can just take a look briefly again at section 18.8 before we come to Dobson.
Just before you do that, do I take it from what you've said that your submission is that both Lord Nichols and Lord Hoffman proceeded on the basis that failing to build new sewers was not a common law nuisance?
There was no
cause of action.
There's no where a statutory where a sewerage undertaker where perhaps I can put it this way, where a claim involves in essence a complaint that there is insufficient infrastructure, yes, the consequence of which to remedy the claim, to remedy the wrong which is being complained of.
Yes, where the complaint is you should have built more
sewers. But I put it the way I do because it's not simply a matter of I can be compensated in damages.
Yes, it's not injunctional damages.
It's not, exactly.
That's why I said the complaint is you should have built more infrastructure.
Exactly. And I accept the way your lordship puts it. Then there is an inconsistency with the statutory scheme because that question is a question which is fairly and squarely within the remit of the regulatory regime, for which there is a remedy under section 18, and for which there might be a remedy under section 95.
Well, that's the exclusive remedy.
We say,
and therefore there is no tort.
Therefore, there is no tort. There is a wrong, if you like, in inverted commas, because it's a wrong for which a remedy can be provided through the statute.
Well, it's a breach of statutory duty.
It's a breach of the statutory duty, there's a statutory scheme which provides remedy for that breach of duty, and there is also within that statutory scheme scope for provision for compensation for individuals.
And do you go as far as to say there is no tort, or that in any event one cannot pursue it because it is inconsistent with statute?
That's perhaps a fine juridical distinction. I suppose we say if the claim is liable to be struck out, then I suppose strictly speaking, if we go back to forms of action, there's no form of action which lies in this court. So it might be said that there is no tort. Certainly, there's nothing justiciable in this court. That's the way I.
But it might be significant if you're wrong on trespass, if discharging polluting matter into the canal as a trespass, because it's not, you don't have the argument that it's involuntary. Suppose you lose on that. What I understood Mr. Hart's argument to be is to say, well, you know, it is a trespass, so it is a tort, and Section 18.8 preserves our rights in respect of it. And I'm not sure whether your answer is that following Marchich, there is no trespass, or it's a trespass, but you can't sue for it because it's excluded.
Whichever formulation one makes, whether or not one says there is no cause of action, or there's a theoretical cause of action but there's no remedy, it comes down to this. It can't be pursued in court applying the Marchich test because the remedy which you're seeking is inconsistent with the statutory scheme. And I respectfully submit it makes no difference whether that wrong would at common law be characterised as a trespass or nuisance, because the remedy comes down to the same thing.
Yes.
So, my Lord, if we can just pick up that point on Section 18.8, probably sensible just to make that point good to have it in front of one tab. Volume 1.1, tab 12, page 140. Picking up this point, it refers, as we've indicated, the primary function is to provide that the only remedies for breach for the contraventions are under this section, but there's a carve out to accept cases where express provision is made, and those that are available in respect of that act or omission otherwise than by virtue of its cost consisting or causing or contributing to such a contravention. And perhaps the 2 points I pick up on the wording. It's not expressly in terms of preserving causes of action, and it also is in terms of those that are available. It's are available. It's not would be available but for the act. So one's looking at the present circumstances. I know that it may be a fine point, but it is at least consistent with our interpretation that in order to decide what causes of action are available, one asks the Marchich question in present circumstances having regard to the particular statute. That's what we say about Section 18, which we've dealt with now several times. I didn't focus on the word sufficiently this morning, but that's what I should have done. My lady, now we can turn to Dobson, which is in volume 2.3 of the bundle. Tab 54, but I'm going somewhat more slowly than I'd anticipated. Page 728, tab 54.
Yes, this is Mr. Justice Ramsey's case.
This is Mr. Justice Ramsey's case. It concerned the unpleasant effects of the Mogden sewage works, in particular odours and mosquitoes caused by the works. It's a substantial piece of litigation, and I don't intend to take your ladyship through the history. We've sidelined the head note and the first two findings, and I don't propose to go through those in detail. We say they summarise the nuts and bolts of the case. In terms of the structure of the judgment, because it's a long one, if I can do the same as I did with marchage take you to what we say the structure of the material parts of the judgment is. So paragraphs 3 to 5, Mr. Justice Ramsey set out the bones of the litigation and sets out what we call the threshold defences, which in essence are similar to the points which we make in support of our declaration. Then going forward to paragraphs 10 to 12, he introduces the issues which we're concerned. There are marchage issues and damages issues and limitation issues. We're obviously concerned with the marchage issues, which he summarises at paragraphs 11 and 12. Paragraph 13 and following, he analyses marchage, and I'm not going to take your ladyship to that. Then at paragraph 21, he sets out the effect of marchage. In marchage, therefore, the House of Lords held that Mr. Marchage could not bring a cause of action based on nuisance or breach of human rights in relation to the duty to provide, improve or extend the system of public sewers. In this case, the question raised is whether the marchage principle applies to all the duties in section 94.1 and in particular those under section 94.1b, and if so, whether this precludes the pleaded causes. Then paragraph 26 to 28, His Lordship referred to the duty to build sewers and reviewed case law. Going forward then to paragraph 35, he refers to the fact that sewerage authorities have no control where sewers are no longer of sufficient capacity due to increased demand put on them. So this has in mind the sort of situation in respect of which we are seeking declarations. Then he refers to the leaky principle, and then he concludes this section. This case raises the wider question of whether the marchage principle is limited to that particular duty under subsection A of section 94.1, or whether it applies more generally to the duties under section 94.1a and section 94.1b. Then points out that the mosquitoes issues outside this particular set of issues, and at paragraph 44 he considers whether claims in respect of odours and mosquitoes were in substance in order to enforce the duties under section 94.1b. Then he refers to British Waterways case. Then at paragraph 48 he deals with what the claimants submit. The claimant submits that section 94.1b is concerned only with effectual dealing with the contents of sewers, and this obligation is only concerned with getting rid of the contents of the sewers, not the environmental protection issue. And then he sets out various arguments, which I don't need to go to in detail. I do come forward to paragraph 71 and following, where he sets out his decision. These are the paragraphs on which we rely, and in particular paragraph 74. He reaches the conclusion that we are in the area of a failing effectually to deal with the contents of sewers. One sees that at paragraph 72 for these reasons, and we adopt those. So and he has six points going over to page 745. I'm not going to read them out loud. Paragraphs 75 and 76, he refers to the British Waterways case, and in particular paragraph 76 he refers to a judgment of Lord Justice Peter Gibson, but there's nothing in this passage where he refers to the proviso which raises, or in which the marchage question is considered. And that's not surprising because at this stage, the stage of Lord Justice Peter Gibson's judgment, marchage had not been decided, so the issue wasn't in play in this context. Then, going forward to paragraphs 81 to 83, or 80 to 83 over the page, he poses the question for him in marchage terms and cannot see why it shouldn't extend to section 94(1)(b). He concludes at paragraph 83 that in substance the claim is seeking to enforce the duties. Then at paragraph 84 he considers whether this precludes claims in nuisance absent negligence, and one sees 86 to 88 how he concludes that nuisance absent negligence is precluded. A claim of nuisance absent negligence is precluded by the statutory scheme in a way that we say can be derived from marchage. So it's first instance authority supportive of what we say is the correct approach. Though going forward to paragraph 89 on that page, he goes on to deal with questions of allegations involving negligence, and he summarises his conclusions on that at paragraph 120. He comes to the conclusion that the distinction to be drawn in this case so that certain causes of action and nuisance based on negligence will exist alongside duties under the WIA. I do so based on the analysis of the second limb of section 94A and of section 18.8. Of course, if one's negligent in the way one deals with contents of sewers, that's a matter of negligence. It's not simply a failure to provide sewers, so it's not surprising that claims of negligence or the intentional discharges of effluent into canals not caused by inadequacy of infrastructure aren't caught. So we then go on. He deals with section 18.8. I should refer your ladyship to paragraphs 138 to 139 on pages 755 to 756. Over to 757. He deals with section 18.8 and he refers to the fact that Lord Nichols himself referred to section 18.8. We say this is supportive of the way we put it, though we perhaps put it slightly more fully just now. And then wrapping up at paragraphs 140 to 143, that contains what we say is essentially the ratio of this part of the case, which is based upon marchage, and we adopt it. So the boundary between what's actionable and what is not is going to be fact specific, but we can go so far on the basis of what we say the principle is, that absence of an action for negligence, an allegation of negligence or some operational failure, an action which in substance simply relates to the inadequacy of infrastructure is not actionable.
Where do we go from there, Mr.
But we are going more slowly than I anticipated, but I have been answering quite a lot of questions along the way.
Absolutely.
The next case I want to look at before we come on to look at what is the effect of the proviso, which I can deal with briefly, and the what's the remedy, which I will deal with briefly, is the case of Barrett Holmes and Dŵr Cymru, which cited Dobson and considered Marchich, albeit obiter, but since it's Court of Appeal authority, in the context of the Water Industry Act, it's appropriate for me to refer to it. It is in volume 2.4, tab 60, page 999. Sorry, I haven't got tabs in my bundle, which means it's somewhat.
This is a follow-on from the Supreme Court decision we've already looked at.
Exactly. So it's round two. In essence, this is the issue was whether or not the developer could bring an action for damages for failure by the undertaker to permit the connection. In fact, the connection had been blocked by the developer. Some summary judgment applications were made. The claim in negligence by the developer was struck out, say for a limited aspect, and the claimant conceded, and this is relevant, that there was no breach of statutory duty, but claims for nuisance and trespass were allowed, trespass to goods by the developer were allowed to continue. The claimant appealed seeking to undo the strikeout, and the water company appealed saying the claims in nuisance and negligence should be struck out. The claimant didn't resile from the concession that there was no claim for breach of statutory duty, and the Court of Appeal dismissed the claimant's appeal and then allowed the appeal striking out the claim for nuisance and trespass. And it struck out the claim in nuisance on the basis that such a claim was inconsistent with the statutory scheme, but it didn't need to do so on the Marchich basis because there'd been no claim for breach of statutory duty, and in those circumstances the court considered that there could be no claim in nuisance covering the same grounds. It's a slightly narrower point, but one sees in the judgment of Lord Justice Lloyd Jones that he did deal with Marchich at paragraphs 18 to 22 on pages 1006 to 7. He simply, in essence, recites the background. Then we refer on page 1008, paragraphs 23 to 27, where he deals with Dobson, and paragraph 27 over the page of 1009, he appears to, in fact, he refers to Dobson with apparent approval, though he doesn't need to consider the reasoning. Then para 31, he indicates there's no freestanding claim in nuisance for a failure to permit a connection. And paragraph 32, he notices the difference because of that with Marchich and Dobson. Paragraph 33, against that background, he asks the question here, is there a consistency with the Act? 34, he refers to the regulatory code in Bowden, which is a case I'll come to in due course. 36, over the page, there's the concession that there was no claim for breach of statutory duty. And at 38, he indicates the policy of the Act didn't give them a claim, though having considered the reasoning in March, one can see it's a narrower reasoning based on construction. And the other judgments I don't need to take the court to, but one can see there, in essence, a narrower sort of case, but where the Marchich reasoning is considered, and for our purposes, Dobson is considered in approving terms, though obviously obiter, because consideration of it wasn't necessary to the decision. So that is where we get to on the authorities on the Act. We say the statutory scheme is one which precludes common law claim, where in essence the claim is that the remedy sought, or the essence of the claim, is that more infrastructure should have been provided. And we say there's no blanket exclusion for by Section 18.8, because Section 18.8 doesn't tell us about remedies. It leaves what remedies exist. One needs to ask the Marchich question, and we say in determining what remedies are available at common law, the key consideration is whether the Act complained of arises out of circumstances which can be remedied by court order without conflict with the statutory scheme. And as I've indicated to your ladyship, in principle, a claim that more sewers need to be provided is inconsistent. So what's the effect of the proviso on this? My lady, this morning I have indicated that the proviso in this case does have an effect on particular words, the particular duties which are independently imposed of the Section 94 duty. It applies to the duty to allow connections. It applies to the duties in respect of preconditions that are required in respect of the stopping up of sewers and the implicit right to discharge. And by applying to those sections, it makes clear that reliance upon the necessity, the obligations put on local authority, on sewerage undertakers by those sections, cannot provide a defence of statutory authority to claims for under Section 94. It resolves the tension with Section 94. It also has the other effect, which I've indicated by reference to Dobson, but I can make the argument freestanding. It keeps open the possibility that claims may still exist where not authorised by statute, where such claims do not have a remedy inconsistent with the statutory scheme. And as we saw in Dobson, those claims can be extensive. One of the on this point, standing back a little, the interveners make a point that proviso relates to water, showing that water is particularly important and can be distinguished from the Marchich sort of situation. Therefore, it's got to be given the force they say. Indeed, one might ask why there is a proviso in relation to water and not in relation to land. That is a good question. But the discharge into land would, of and in itself, be objectionable as a breach of the Section 94 duty effectually to drain the area. That's so regardless of whether the discharge onto land carries a pollutant load. On the other hand, a discharge carrying a pollutant load into water, a discharge into water, indeed even one carrying a pollutant load, might arguably not be objectionable. It's certainly not objectionable in the same way. Because as one's seen when I took your ladyship, and in answer to my Lord Justice Nugee's question about the nature of sewers, and I referred to MEDA, it's in the nature of sewers that they discharge somewhere, and historically that has been into watercourses or the sea. And it's for that reason it's not surprising that water is dealt with in this way. But as I say, that its function, we say, is one that is explained within the context of the Act.
So does that come to this? For watercourses, you don't need to say you can't discharge clean water, because you can discharge clean water. What you need to say is you can't discharge foul water in such a way as to prejudicially affect. For land, you don't need to say anything, because discharging clean or dirty water is not disposing of the water. It's not effectually draining.
Yes, quite so. That's what it comes down to. That's why we have that's why, in my respectful submission, one has a I won't put it high, but I'll say it's not surprising that one finds the proviso in relation to watercourses. It doesn't privilege watercourses. It's actually what it does is explain, or it arises out of the relationship between sewers, the inevitable relationship between sewers and watercourses, because sewers discharge somewhere. Historically, they discharge either into the sea or into some sort of watercourse. It's not the main point that we make about in relation to the point about being OTOs, but it's if one likes an explanation of why one needs this particular provision and why you don't have something in relation to land. And my lady, then coming on to the third point, which was what's the remedy where the provisos are breached. I've dealt with that in the course of argument. We say where the provisos are breached, provisos, neither of them, neither section 1175B nor section 1863 tell us in terms what the remedy might be if there is a discharge without authority, and we say whether there is a remedy in court depends on whether or not the claim is one, in essence, to require the building of more sewers, which we say would fall within section 94, which we say would make it incompatible with the statutory scheme in the Marchage sense. So that's the way we put it, and I've put it now several times, so I think I've made that point good. I now have to deal with what was called the rich jurisprudence, both before and indeed after the privatisation regime. I won't take the court through all the cases we have set out in the appendix to our skeleton response to the interveners. I will, however, have to take the court to a number of cases, and I'm going to look quickly at the following cases: the Glossop case, the Dorking case, Jones and Llanrwst, which was referred to by the interveners, and I think also my learned friend Mr. Hart in skeleton, the Pride of Derby case, Radstock, which Mr. Hart referred to, Bowden, which is referred to by the interveners, but I'll deal with that briefly, and then briefly with the extract from the judgment of Lord Justice Keane in BWB. I won't deal with the Southern Gas case because I think I've adequately dealt with it, I hope I've adequately dealt with it in discussion with my Lord Justice Nugee. So if we can come to Glossop first of all. Glossop is in bundle 2.1 of the authorities bundles, tab 22 on page 8. We've sidelined the head notes. The defendant was a local authority with sewerage functions under the 1875 Act and had acquired a pre-existing sewerage system. The plaintiff complained that sometime before and since the defendants became the sanitary authority, sewage was allowed to fall into a stream near his home so as to pollute it and cause him a nuisance. So he brought an action claiming nuisance. It was held that he did not have a claim. If I can take you to the judgment, first of all, of Lord Justice James on page 16 of the bundle. The first sideline passage, if the sewer being in the state in which it was transferred to them would, independently of the Act of Parliament, give any landowner or any riparian proprietor a right to an injunction to restrain the use of that sewer or the abuse of that sewer, it appears to me that they would be in the same position as any other owner of the sewer would be. But the case here is not based on any common law nuisance or any nuisance existing or any damage existing irrespective of the neglect of the Act, but upon the alleged neglect to comply with the provisions of the Act. So essentially one's looking at the interrelationship between the substance of the claim and the Act. Of course, it's pre-Marchage, but one can see the sort of reasoning that then Lord Hoffman extracted. Then further down the page, by the 14th section, any person who has acquired a right to use a sewer shall be entitled to use the same or any substituted in lieu thereof, to the same extent as he would or might have done if the purchase had not been made. Then the 18th section provides the local authority may from time to time close a sewer, and then it refers to the condition attaching to section 18. Now, therefore, over the page, they were in this position. There were certain persons who were using the sewer. If they were using it unlawfully as against the plaintiff in respect of the rights of property as they stood before this Act, he had no remedy against them, and in no way deprived by this Act or anything the defendant had done or permitted to be done of any such right. Then the further material passage to which we refer goes on to deal with the statute. Pages 20 to 21, at the bottom of page 20, he says, therefore, it does not appear to me they were guilty of neglect. If they had been guilty of any refusal, such as is necessary for the purpose of applying for mandamus or any mala fide delay, for it must be brought up to that to make it to equivalent to a refusal to take steps, if anything of that kind had occurred, that is not the ground of an action for a proprietor in the district who may be deprived of the benefit he expected to derive from the performance of that duty. The neglect to perform a public duty for the whole of the district to enable anybody and everybody to bring a distinct claim or to file a distinct claim because he has not had the advantage he otherwise would have been entitled to if the Act had properly been put into execution. It appears to me the country would be buying its immunity from nuisances at a very dear rate indeed by the substitution of a far more formidable nuisance in the litigation and expense that would be occasioned by opening such a door to litigious persons or to persons who might be anxious to make a profit and costs out of this Act. So one sees there as part of the reasoning, it's not the full reasoning, but Lord Justice James sees the tension between the common law and the particular statutory scheme that he was considering, and finds that that tension is part of the reasoning from saying there can't be a common law claim. And that finds its expression, we respectfully say, in more modern terms, in March. Of course, at this stage, the law of nuisance hadn't developed. We hadn't had Sedley Denfield, no Canahan, and the leaky principle, but one sees here the Court of Appeal taking, at least in part, we can call it a proto-Marchage approach.
Can you help me? Why are we looking at this?
Well,
what does it add to Marchage? I mean, if you win on Marchage, this is redundant. If you lose on Marchage, how does this help you?
Well, I'm referring to this simply because we are told by the interveners and indeed by Mr. Hart that there is a rich jurisprudence which supports their interpretation both of Marchich and the proviso. I would not be referring to this case if we had not been facing a claim that the prior jurisprudence was relevant. So I'm with your lordship. I would rather not be referring the courts to this, but we are dealing with the case that we're meeting the case which has been set against us on paper. Now we refer to this case, and it's fair to say this isn't referred to by the interveners. We refer to this case because this case provides the antecedent for understanding what was going on in Jones and Llanrwst, which was a case to which they refer, and it also forms the background to an understanding of what we say Lord Justice Denning got it wrong in Pride of Derby, which again is a case which is said to form part of the rich jurisprudence which we are up against. So I agree with your lordship. I don't want to trouble your lordship with this, but I'm afraid I have to. Does that answer your lordship's question?
Thank you.
And there's a similar question being framed by Lord Justice Brett on page 25 of the Act, and the case. I'm so sorry, where he frames the issue by reference to the duties. He does it in a slightly different way, but again, one likes starting to grasp towards a Marchich analysis. And on page 28, one sees a conclusion at the top of the first main paragraph at the top of it. Then it's said that nevertheless the defendants are liable to mandamus to their duties. So again, looking at public law is where the remedy is found. Though of course in later cases, until the mandamus wasn't the remedy, one had to go through the section 299 procedure. And there's similar points in the judgment of Lord Justice Cotton. One sees on page 35, the paragraph. There are two other points. Again, he's looking at the case in terms of context of the agreement. The next case, again, which provides part of the antecedents to Jones and Llanrwst, which we'll come to afterwards, is the case of the Attorney General versus Guardians of the Poor of Dorking Union, which is in this bundle, tab 23, page
37.
37. It's 37. Oh, thank you, my lady. Again, this is another case in which the authority inherited sewers. They were inadequate. New connections have been made since vesting in the authority. The claim there was a nuisance held no nuisance. The remedy was a claim for mandamus to require the authority to comply with the duties. The reasoning of the Master of the Rolls is at page 46. I'd ask the court to read the sideline passage. And essentially we say what he's grasping towards there is the point about the inconsistency between saying that there's a common law claim and the statute, because the statute puts the local authority in a different position to other people. It's got a limited right of ownership. It can't do anything to stop the connections. And on page 50, Lord Justice Cotton refers to Glossop Could it be said for a moment that closing up this sewer without providing another system of sewers would not cause a great nuisance to every householder who previously drained into this sewer? It's not only so as regards those already drained into the brook, but under the Act of Parliament, every householder has a right, if this house is within a certain distance of this sewer, conducting his drain into it. And he refers at the bottom of the page to section 17. And we don't go so. And he makes the point there that there's nothing. The proviso doesn't mean that they, the authority, are to be considered as using it themselves, either by themselves conveying or granting permission for sewage to be conveyed into the stream by means of the sewer. So, as part of the rich previous jurisprudence, we see section 17 being treated in a different way. I don't rely on it to support my case. I rely upon the Act within its, the 91 Act within its own four corners. But I say, if there's a rich jurisprudence, it doesn't, on its face, undermine what we say, or at least all point one way. Then, I see it's 4 o'clock. I'll certainly be able to deal with Jones and Llanrwst, and then perhaps we can see where we go. Jones and Llanrwst is in volume 2.1 at tab 33 at page 174. The local authorities' predecessors, who by statutory devolution, the defendant local authority was responsible. The local authority was responsible for the actions of its statutory predecessor. The statutory predecessor had constructed and then altered a sewage system which discharged into a river of which the plaintiff was a riparian owner. The sewage wasn't treated and it caused a nuisance. And it was held that the local authority was liable. Page 183 explains the nature of the claim. The first question is nature of the riparian rights, and the second question was whether the turning out of the pollutant matter was actionable. Then on paragraph 185, I'm afraid we haven't sidelined it. The first main paragraph defines the point. With regards to the first point, is reasonably certain that a reversioner cannot maintain actions in the nature of trespass. So that's a point we're not concerned with here. The second point is whether the sanitary authority can be sued. And then he deals with the second point at the bottom of the page. The second point is of greater difficulty. And he refers to Glossop. And at the top of, and on page 186, over the page, he explains what he thinks Glossop says. And on 187, he distinguishes Glossop on the basis that he didn't think that the claim in this case was in substance a case of seeking to compel compliance with the authority's duty to construct a sewer. And we see the reason he did so on page 188, where he describes the facts. And in essence, what had happened was a system was designed to work in a way that was intended to work. But we see as a matter of fact, this is a matter of fact, however, just before halfway of the page, sewer number 2 was either never connected with sewer number 1 at all, but taken straight into the river, or if originally connected with sewer number 1, was shortly afterwards disconnected therefrom and taken straight into the river. Now, each case will turn on its own facts, but in this sort of case, it might be, depending on the facts, that this would be a case of operational negligence. It's not a case of failure to provide infrastructure, it's negligently carrying out the works, possibly, because each case will turn its own facts. It is a very different case from the sort of case which we are seeking. It stems from what appears to be an operational failure in the implementation of the duty rather than the simple failure to provide service. That's how we respectfully say the matter can be distinguished. It's a case on its facts, and its facts, as we say, might actually today, even on our principles, depending on how they panned out the particular findings, still result in liability. So we say it's not surprising in this case that Glossop was distinguished and an action in negligence remains. So again, though part of the jurisprudence, it doesn't actually assist, as has been suggested in the interveners and Mr. Hart's skeleton argument. The next case is Pride of Derby, and I'm in your ladyship's hands.
Do carry on.
Right, if we can put this volume away, turn to tab 2.2. And again, what I'll try to do, as I did with Marchich, is give headline points to how we say the judgments are structured and how, in essence, we say it provides no support, or perhaps I should say little support, to either the interveners or to the Manchester Ship Canal. Your Ladyship has seen the head note. I don't propose to take your Ladyship through it. At page 340 to 341, however, I do emphasise these paragraphs. It's a point which your Ladyship picked up. Tells us what this case is about. This case is about the Derby Corporation Act. Then at 343 rather, we see the way the case was being put by Sir Andrew Clark. Now, it's clear that if a public authority so exercises any of its functions as to cause a private nuisance to any person, the authority is liable in consequence to be sued in these courts as any other subject is liable, unless it can rely upon some statute as providing by express language or necessary or proper inference a defence to such an action. But the way it was being put, as one sees from the judgments, is the classic defence of we have statutory authority. It wasn't, the question wasn't being asked in Marchich terms. And one can see the boldness of Sir Andrew's submissions when one turns the page and sees the particular statutory provisions against which he was labouring, because there was an express provision in section 109 for the protection of the parish of Spondon, which provides the sewage disposal works constructed on lands acquired under the powers of this Act shall at all times hereafter be conducted so that the same shall not be a nuisance, and in particular the corporation shall not allow any noxious or offensive effluvia to escape therefrom, or do or permit or suffer any act within which shall be a nuisance or injurious to health or reasonable comfort. So we're dealing with an express statutory duty not to cause a nuisance. So it was somewhat bold of Sir Andrew to argue that the effluvia was authorised. Then 344 to 349, the judge looks at the detailed provisions, and at 349, second paragraph on 349, he agrees with Mr. Justice Harman that the discharge through this pipe of the effluent from the sewage disposal works is not only something not expressly or impliedly permitted under the Act, but is in terms expressly prohibited by it. If that view is right, it is, as Sir Andrew Clark frankly admitted, the end of the appeal by the corporation on their main point. So they didn't go on to consider the March question. Then he goes on to consider some points about the Public Health Act, but these are clearly obiter, given the finding which we've just seen. He having reviewed the authorities at some length, it go on to 354. He says, whatever the true ratio decidendi of the judgments in Glossop and Dorking, cases which we've just seen, they must, I think, clearly be taken as deciding that where a local authority has inherited drains or sewers under the Public Health Act, and those drains or sewers constitute a nuisance by reason only they have ceased to deal adequately the sewage of the authority's district, then the local authority not having themselves been at fault, save that they have not used the powers vested in them to enlarge the sewerage system, are not liable to be sued in the courts, for such an action would be, in effect, an action to compel the exercise of the statutory powers or performance of the statutory duty by a local authority. We say perhaps the reasoning can be looked at in a slightly more sophisticated manner because of the inconsistency between the acts, but in essence, that's one view of what they decide. He then goes on to look at section 17 of the Public Health Act, albeit obiter, and what he says, it does not involve a prohibition against the local authority permitting the inhabitants of their district to put sewage in the local authority's drains or sewers. And that's a point which was picked up, I think, in Dorking. Then, over the page on 356, he deals with negligence, as regards negligence, and what he appears to be saying here, we say, is that in the context of negligence, the difference between misfeasance and non-feasance might matter. But he says obiter, in the context of nuisance, the distinction doesn't matter, and the question there is one of authority. And of course, we say that's not the question we need to ask in Marchage. It is the question which he's considering in this case, given the defence run by Sir Andrew Clark. Over the page, or over to page 359, first full paragraph, the result therefore seems to me to be that the question whether the principle of the Glossop and later cases applicable only where the authority sued has not itself constructed the sewers complained of as creating nuisance by polluting has not yet been actually decided. So he's making the point. The point is an undecided one in terms of rich jurisprudence, though over the page he suggests there would be liability, in my judgment, as at present advised, there would be liability, but of course he's not there considering the Marchage questions. And at the bottom of page 35, going back to 359, he makes a point that we're dealing with sewage disposal works rather than public sewers. I'm not sure that should make a difference. And at the bottom of 360, he distinguishes Glossop on the basis that the that in Pride of Derby, the claim was made in respect of provisions outside the local authority's area. The point being that the individuals affected weren't in substance seeking to enforce the local authority's duty to provide more sewers effectively to drain Derby. What he doesn't suggest that if the claim was made by the people of Derby that their own area was ineffectually drained, they wouldn't have a claim. But for what it's worth, that seems to be what he's saying. But again, he doesn't actually grapple with the remedies question, which we say needs to be grappled with. Then Lord Justice Denning's judgment starts on page 367. He deals with Sir Andrew's argument that there's a difference between misfeasance and non-feasance. Of course, that's not the test for Marchage. Then over the page 369, Lord Justice Denning makes the point that this distinction only, he says, applies in highways cases. And he goes on to debunk the notion that there should be a distinction between misfeasance and non-feasance, and says, wanted rid of that, on page 369, the second main paragraph, that the case can be reduced in simple terms. The first question is, have the plaintiffs at a prima facie cause of action in common law? If so, the second question is, do they have statutory authority? What he's not considering, of course, is the question we are considering here. He goes on then at page 370 to look at Sedley, Denfield and O'Callaghan at the top of the page. He then goes on to consider historic cases, and at the bottom of page 371, he in turn suggests that local authorities are now liable for increases in sewage because they are responsible for permitting development under the planning regime, which is not a line of reasoning which is consistent with Marchage, nor indeed can stand with the current regime, because of course sewerage undertakers have nothing to do with the planning regime, albeit that they can, as pointed out in the first Barrett case, make representations within the planning system. Then from 371 to 372, it deals with statutory authority, refers to section 17, excluding statutory authority, but he's not asking the question we say here. But an important point to which we do draw attention is on 372, in the way he deals with whether an injunction should be issued. Sir Andrew Clark asked that an injunction should not be issued. The corporation, he said, could not dam back the sewage because that would cause a most frightful nuisance to the inhabitants of Derby. They could not extend their sewage disposal works because they were prohibited under the defence regulations from doing so without the consent of the minister. These are strong reasons for suspending the injunction, but are not reason for not granting it. And he goes on to say, and these are the words to which we draw attention, the power of the courts to issue an injunction for nuisance has proved itself to be the best method so far devised for securing the cleanliness of our rivers. And in this connection, it is significant that the law relating to nuisance has been expressly preserved by section 11.6 of the Rivers Pollution Act. The issue of an injunction does not interfere with the power of the minister to determine the proper order of the priority of public works, but it does mean that if these works are to be deferred, the court will want to know the reason why. Only an overriding public interest will suffice. But of course, that simply cannot sit with paragraph 70 of the way Lord Hoffman put it, or indeed the whole gravamen, we say, of Lord Nichols's speech. Because Lord Denning is considering that when granting an injunction or not, or exercising an equitable jurisdiction, the court will decide where the public interest lies. But we know, certainly under the 1991 Act, that there's an elaborate statutory mechanism and indeed duties imposed upon the regulator and minister for determining what is or is not in the public interest. So we say Pride of Derby really doesn't assist, and indeed the judgment of Lord Justice Roma on page 373 is to a similar, well, that takes matters no further because he proceeds, as one sees from the first paragraph, on the basis of the construction of the 1901 Act. And while he refers to Section 17 of the Public Health Act, he does so in terms which, with respect, don't take matters, we say, any further. So that is Pride of Derby. I can deal with Radstock very quickly if your ladyship's happy, or not. I'm in your ladyship's hands.
Radstock is the
last.
of your...
Well, it's the last of those referred to by Mr. Hart, but there's then Bowden and BWB, which are referred to by the interveners, which I need to deal with briefly. But Radstock is a quick case because there are only a couple.
Let's look at Radstock and then stop.
Radstock is in volume 2.2, which is this volume, tab 43, page 415. As your ladyship will remember, it concerned a sewer which had been laid properly in a river, but due to the increased flow of the river caused by erosion of the riverbed, the sewer was exposed. The flow of the river changed, causing harm, and the claim was brought under three heads: common law nuisance, breach of covenant under release, and breach of the provisos under proviso under section 331, which is now our section 186. And there was comment on that proviso, the section 331 proviso, page 438. In the judgment of Lord Justice Harman, merely preserves the common law rights of persons injuriously affected. So, on the face of it, consistent with being against us. We'll explain why it takes matters no further in a moment. There's a similar dictum of Lord Justice Russell on page 441, which we've sidelined. Mere saving of common law rights. Page 443, judgment of Lord Justice Sachs, which was dissenting again. He simply refers there to a cause of action, but he also refers at 450, preserves the relevant rights of riparian owners as regards nuisance. There are 2 points we make here. First, the issue in the case was whether or not the proviso gave rise to a freestanding cause of action. It wasn't, in fact, the full extent and operation of the proviso there. And secondly, following from that, what the question of what the courts were dealing with, there is nothing here to suggest the precise extent to which common law remedies might or might not survive. And for that, we say the Marchage question can be answered. And we say the reasons I've explained, that the proviso, in any event, leaving aside common law remedies, has a particular purpose within the context of the Act and its application to sections 106 and 116. Lady, that's probably a convenient moment. Then I hope to be able to speed up. I did say yesterday that I'd be just over a day, though this morning I said I'd be within a day.
I remember the last. But not
Yeah, for which I apologise. I should have stuck with my my original suggestion.
Okay, so we've got 2 more cases also.
Then
EWB and yes.
and
then
MSCC. I don't need to deal with Southern Gas Water. I will then spend, I would hope, no more than 20 minutes to half an hour dealing with the remaining grounds, which can be dealt with very, very quickly. Then I can deal with the paragraph 50 point, as it used to be called, but the license of the licenser's point, as it's now called, point dealt with by Mr. Morgan very quickly. The principles on which we rely,
so you're going to be about an hour and a half tomorrow morning?
I would hope so.
Fine. Thank you very much indeed. 10:30 now.
Bye.